can you please look up this thing?
See if we can figure out something.
Is that one your computer down?
I do not know.
I left that yesterday.
Yes, Danny.
Got a DNA sticker on.
That's Matt. Okay.
Jack Arnold's.
It probably is.
He leaves stuff everywhere. I can take it back to the office.
I don't know if Jack was here yesterday. Nicole was here. And actually, that's about where Nicole was sitting at.
Huh? I don't guess so.
I ran from like Springfield. I think it was Springfield down through, all the way down through Charlotte, down into Dixon. It was 50 or 55 miles.
Better him than me, I like to say.
It was some kind of oil run or
Yeah.
something like that.
Well, they did one not too long ago for Waverly.
Do a 3K, that'd be not. Really get called.
Long enough. Yeah, see that, I could do that better than.
That was still pretty tough.
My brother is trying to get me to run a marathon in Nashville.
26 miles.
At least after 5, right?
And that one. The reason I went into this, I didn't know it was. And Bill said,
they zooming your guy?
Oh, no, Lisa Tidwell, is Matt's client who's supposed to be here. This is supposed to be her trial day too. And as far as I know, she's tonight.
All rise. This county is now in session. The Honorable Judge David Wolfe is presiding. All you have business before this court draw nigh, and you shall be heard. God bless the United States, this state, and this court. Have you seated?
Good morning. We are ready to start. I think first I have a couple of things I need to take care of. One of them is the Lisa Tidwell case. Is that correct?
Yes, Your Honor, she was set for trial today.
All right, then we are ready to, she showed up.
That I can determine your.
I'm sorry.
I cannot determine that she is here. I looked for her and called out before I entered.
Do we have a bond from Miss Tidwell? What's the first name?
Lisa,
I think it was 5,000.
We have an appearance bond by Pfizer bonding in the amount of $5,000. All right, Ms. Tidwell's failure to appear for a trial date to be a conditional forfeiture of a bond in the amount of $5,000 that can't be issued for her arrest. Clarification of the bonding company set the final forfeiture for March the 29th. And an arrest warrants were issued for the defendant. New bond will be set at $10,000. On her arrest, we will set a new trial date. I suppose you could say better late than never, except for that. Have you had any contact with her?
I have never had contact with her, Your Honor, but Mr. Mitchell has. It's just, she has not responded to.
Judge, I'm Ms. Tidwell.
Ms. Tidwell, come up. Today's your trial date. You ready? Come on up. Tidwell, you're here for a trial, and you're in charge of theft. And it is a Class D felony, so you're looking at prison time. You ready to try your case? Let's give Ms. Tidwell a tissue to spit her gum out when she's standing in front of the court.
Your Honor, may I whisper to her real quickly? I'm calling you Judge with me. We'll do it. Your Honor, Ms. Tidwell has advised she will accept the offer.
If you could give me just a minute to write up some police speaker.
The other case that we have on the docket is State versus Christopher White. And then the third case rather is State versus Dylan Wade Stewart, which I'm understanding is a Department of Corrections inmate who is going to be here at 1:30 for disposition. Am I correct about that?
Yes, Judge.
All right. And are we ready then on State versus Christopher White?
Yes, Your Honor. We're ready, but I have a preliminary matter I need to address the court on.
All right.
If I may.
Number one, your client, has he signed a waiver of his right to a jury trial?
We submitted that quite some time ago. It should be in the file.
Make sure. Thanks. You have something you just wish to raise?
Yes, sir. Judge, Mr. White was indicted in this matter in August of 2016. I filed a request for discovery. I believe it was in late November of 2016. I've had discovery issues with the state from day one, mainly because the alleged victim in this case has failed to cooperate with the state apparently. Even in 2018, in November 2018, when I filed a motion to dismiss for various reasons, the issue of discovery was brought up before the court. At that time, the court said, file your motion to compel. Well, what I did was in August of this year, and let me just say this, I've had communications with the state assistant district attorney, this general as well as the general before, regarding the production of evidence, pictures, checks, documents, and so forth, over and over again. I filed the motion to exclude evidence on August 26th. I believe it was heard on September the 19th. One of the issues had to do with any type of checks or documentation to support the claims that Ms. Bear/Monk was raising. At that time in open court, the assistant district attorney stated to the court that I believe that she's going to be providing those. Okay. Came into court yesterday. I asked the assistant, where are my checks? Okay. As late as it was, even he didn't have them. This morning, as I'm driving in, apparently I get an email from the assistant, now has a big stack of checks and bank statements right there on the table that I have no way of reviewing before we go to trial in this case. This is clearly an attempt by not the state, but the victim in this case to get the alleged victim, I should say, to get a continuance. I filed a motion to exclude evidence under Rule 16D. Under 16D, that clearly gives the court discretion to bar any of this type of evidence that has been clearly untimely filed or submitted, and it is a great prejudice to this defendant. Judge, I have to, if the court allows this into evidence, I have an ethical obligation, as well as my client has basically confirmed that we have got to take the time to review all this stuff to see if it's even legitimate. I mean, I don't know if she photoshopped this or what happened with this. I don't even know if the assistant district attorney has even looked at this stuff. So I would ask the court to exclude this.
Woodall?
Your Honor, I can get Ms. Monk on the stand, but she informed me that she had just gotten these records last night from the bank. I know I was hoping to get these as soon as possible. I know we had court the 19th. I was hoping to get these right after that court date or have them available on the 19th. But unfortunately, that did not happen. I received them this morning. As soon as I received them, I forwarded them to Mr. Scruggs. These, I would subject to the court that these bank statements and checks are relevant to this case. Especially, I would submit to the court that we intend on proving through these checks how much Ms. Bear paid after the defendant stopped working on her house to complete her house and fix the problems that she had to deal with. That is relevant in this case because in these types of cases, restitution is determined by the amount the victim paid minus any value of the construction that was done by the defendant, plus how much the victim had to pay to complete or fix the project. So it would be, these checks would be very relevant to this case and to the state. As you know, Mr. Scruggs filed a motion for speedy trial yesterday. Here we are. I know this is late, but they are relevant to this case. And if we need to take a break for reviewing these during this trial,
This case has been pending since 2016.
I understand that, Your Honor.
And you were second, I think, maybe the third assistant district attorney. It would seem to me that would have been sufficient time for the state to obtain its, whatever information it needed to have to Because this is an issue that arose in 2016. It's not like this is an ongoing
I understand. Your Honor.
issue. So that's my concern is. And if I grant Mr. Taggs's motion to exclude this evidence, does the state have any evidence then to proceed with this case?
We have, yes, we do have, we would have evidence as to, the,
But if you want to present your proof as to how this came into your client's possession and why it's taken 6 years to get it, I'll be glad to let you put that proof on if you want to do
I can do that.
that. I'll call your witness.
I'll call Mr. Monk.
Step around, please, ma'am. Raise your right hand and be placed under oath.
Your Honor, are the TVs, broadcasting out there because you have witnesses out there?
He solemnly swear or affirm that the testimony you are about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
We'll wait and see.
Good. We're ready.
Please state your name for the record.
Rebecca Monk.
And regarding these bank statements, can you please explain to the court why it's taken so long to obtain these checks and the statements?
Yes, sir. I originally had everything in boxes and in my basement. Our closed washing machine flooded or leaked. They all got damaged. A lot of these accounts are closed, and I had to go to the banks and ask them to pull. After so many years, they purge and they send off, I guess, to a backup site or whatever. And I had to ask them to get them and give them to you.
When did your basement flood? What year was that?
About 3 years. 3 years ago.
And you said you had those bank statements then?
Yes, sir. They were all just boxed up because
Did you ever give those statements to anybody in our office? You recall?
I can't recall.
Okay.
I don't know if it was even asked at that time.
But these statements that you emailed me this morning, when did you request these statements?
I requested them at the end of last week after we had the meeting, or you told me I needed to get them the last time we were in court.
The bill 19.
Yes, sir. And then, so they had to send off, and they don't keep the records at the bank right there. They have to actually send off for other, I don't really know how the bank does it, but they just had to request it from something else, Home Branch or something. Yesterday is when I picked them up.
So questions, Mr. Scruggs, might have some questions for you.
May I hand the witness a document, please?
Pardon?
May I hand the witness a
Yes.
document?
Just hand it to the bailiff.
Ms. Monk, would you take a look at that document, please?
Yes, sir.
You recognize that document?
Yes, sir. I think it looks like it was a breakdown of purchases of a receipts that I submitted at one point or another.
It looks like a breakdown of a list of receipts you submitted to the district attorney's office that was allegedly in support of your claims of what you spent to complete the house. Is that correct?
Yes, sir, it does look like that.
And that was submitted in 2018, isn't that right?
It looks like it. I don't know when it was submitted. I know I sent a whole bunch of copies of receipts
Okay, so the district attorney's office asked you for receipts.
and I sent those.
You sent those.
Mhm.
Did the district attorney ask you for the canceled checks that shows that you actually paid for these items?
I can't remember.
You can't say one way or the other,
No, sir.
but clearly as early as 2018, you had put the DA's office on notice that these were items that would allegedly support your claims. Is that correct?
Yes, sir, but some of these aren't, I don't know if, like, there's a $26,000 one, that was just a, quote, it didn't get paid. That did not get paid.
Right. You sent the district attorney's office
Quotes and everything. I sent them
received
everything. I had.
everything that you had,
Mhm.
but for whatever reason, you forgot to send them the bank statements that may or may not support these claims, correct?
Yes, sir, I guess so.
Well, you guess so. You think maybe you sent them to them and you just don't remember?
I don't know if I recall ever needing to give that information because this was all about not what I spent, but about the fact that he took money from me. I can prove he took money from me based on his records and my records. That I'm not trying to get above and beyond that. He took $295,000 and left me with the shell of a home. My retaining wall was gone.
Okay, so let's just clarify this. The district attorney and I have already agreed to the schedule that shows that you paid about $295,000 for the home. We've agreed to that. We stipulated that.
Yes, sir.
Okay, so then these checks, these bank statements really are not relevant because they deal with things that occurred beyond the 295, correct?
They occurred, that's what I paid, but the 295, the house originally was $268,000. I paid 295. There were two change orders.
I understand that.
Things were done to the
Let's
house.
focus on what these bank
Right,
statements.
well, this right here proves what I had to do that he should have done.
Right, I understand. And the bank statements allegedly are related to that, correct?
Yes, sir, that's documentation to support these things, like the $4,037.50 that I had to pay somebody to install. And honestly, $14,876, I couldn't get the bank to give me those records because they don't go far enough back, so those are not in there.
Those are my questions, Judge. I'll take that back.
Anything further, Mr. Woodall?
Hang on.
All right, ma'am, you can sit down.
I would like to be heard briefly on that. Don't mind. We have entered into some stipulations that I was going to present and during opening statement in terms of the contract and in terms of the expenditures. Mr. Woodall made a statement somehow to the effect that my client is liable for what it costs to complete the house. I would respectfully disagree that that is a correct statement of the law. Now, maybe if this was a civil case for breach of contract, they would have that argument.
I'm agreeing with you, Mr. President. It is not a case where the court is going to set. In my opinion, it's the statute that we're dealing with, and that statute is 39-14-154. And it basically is alleging in count one of the indictment that the the amount of billed for the home improvement services was substantially greater than than the amount put in the contract. The materials used in the project were of substandard quality, but the residential owner was charged for higher quality, and the residential owner did not provide a written consent for the home improvement services provider to deviate from or disregard plans or specifications in the contract. And such deviations cause substantial damage to the residential owner's property, which such damage is the value of $570,244. That's the indictment. Mr. Woodall, you have anything else you want to offer?
trying to find the part of the statute where. Yeah. Under section C1, Your Honor. It says a violation of subsection B is punishable as theft pursuant to section 3914-105. Value for the violation of subsection B, which is the offense of new home construction. Which is what we're going under. Shall be determined by the monetary amount of the new home construction contract or contract for home improvement services that is paid, minus the value of any work performed, plus the cost of repair any damage to the home buyer or residential owner's property caused by the new home contractor or home improvement service. So I would think that it would be relevant, the amount of value that she had to complete her project. or
And these
complete her-
checks are basically verification of what what she will testify to, is that what you're saying?
Yes, Your Honor. That's the value of what it costs you to fix the house and complete the house.
Well, I'm gonna take a recess and review the file to determine the discovery requests that were made and look at the docket sheet on this case so that I can make sure of what I'm doing. Before I do that, Ms. Bryson, you and Ms. Jones have a matter to take up.
Yes, Your Honor. We have a plea agreement.
All right. All right, I've been handed a document indicating that Ms. Tibble is set for trial today, but that she is accepting a plea agreement whereby she would enter a plea of nolo contendere or no contest to a Class A, an amended charge of Class A misdemeanor theft, to receive a sentence of 11 months or 29 days, suspended of probation, and restitution of $5,000 that she would pay the court costs. Tibble, if you'll raise your right hand, let the clerk place you under oath, please.
Nothing but the truth, so help you God.
Thank you. State your full name for the record.
My full name is Lisa Diane Tibble.
Ms. Tibble, you are here today charged with felony theft. It's been indicated that your lawyer and the state have agreed to allow you to enter a plea of no contest to a misdemeanor, amended charge of misdemeanor theft. But do you know what you're charged with? Have you had a chance to talk to Mr. Mitchell, the public offender, and Ms. Jones about your case and discuss with them the range of punishment you're facing, as well as any possible defenses you might have?
Yes, sir.
You understand that you have a right to plead not guilty and to have a trial today. And today was your trial day. You understand that?
Yes, sir.
You understand that if you went to trial, you'd have the right to have a lawyer and have one appointed for you if necessary, which we've done with the public defender's office.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent until such time if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything.
Yes, sir.
You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena.
Yes, sir.
You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything. And that no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty of a crime, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're giving up your right to, or pleading no contest, you're giving up your right to a trial and to an appeal. All I'm going to do is approve what your lawyer has worked out.
Yes, sir.
Now, a no contest plea means you understand what the state's evidence would be. You're not going to admit that you did anything, but you're not going to deny it. And as a result, the state's going to give me some facts to support a finding of guilt. Do you understand that?
Yes, sir.
And that's going to result in a conviction. That conviction will be on your record in the future to make more severe the punishment you receive if you are ever again convicted of a crime.
Yes, sir.
You understand all the rights that I've explained to you.
Yes, sir.
Do you wish to give up your right to a trial by pleading no contendere or no contest? Is your decision to plead no contest today voluntary?
Yes, sir.
Anybody forcing you to do this?
No, sir.
You understand I can't accept your plea unless I'm satisfied that you are in fact guilty and that there are facts to support it.
Yes, sir.
And I want you to listen as the state tells me what their evidence would be if this case went to trial.
Judge, if this case went to trial, the proof would be that between January the 4th of 2022 and February the 12th, 2022, Ms. Tidwell had stepped in as a caregiver for some animals in the home of the victim, Ms. Wagner. During that time, there were several cell phones, watches, iPads, gaming systems, miscellaneous items that were removed from the home. There was a recorded phone call between the victim and Ms. Tidwell that Ms. Tidwell admits to taking several of these items.
All right, and Ms. Tibble, I'm not asking that you agree that those are accurate facts, but do you understand that's what the state's evidence would be if this case went to trial?
Yes, sir.
Do you still wish to plead no contest? Are you satisfied with your attorney's services?
Yes, sir.
Feel like the public defender's office has done a good job of representing you?
Yes, sir.
Ms. Jones, do you know of any reason that she should not enter this plea?
I don't know.
Then Lisa Tidwell in docket number 2022 CR 153, upon your plea of no contest to the amended charge of Class A misdemeanor theft, to find you guilty, sends you to 11 months and 29 days in the county jail that will be suspended to probation in order to pay a $5,000 restitution and pay the court costs. And she'll need to see the probation department today, Ms. Jones, if you will assist her in that regard.
You'll need to go upstairs too. I mean, go upstairs. Go down the hall to the clerk's office and they'll figure your cost. You call them this way and go see her. When you know, no, she's not here.
All right, I'm going to take a short recess, so let me review this file.
Good job. Transcript of the hearing we had in November of 2018. I've got my copy here. That's not, you got a copy of that, right?
Yeah, I got it.
Yeah, fine. Thank you.
I'm gonna wait.
And copy or photo. Defendant's motion. The defendant's motion this morning is based upon the discovery rules under criminal cases, which are found in Rule 16 of the Rules of Criminal Procedure. And upon the review of this file and the review of the record, here's what I find. Rule 16, subsection F, actually 1F, provides the following. Upon a defendant's request, the state shall permit the defendant to inspect and copy or photograph books, papers, documents, photographs, tangible objects, buildings, or places, or copies or portions thereof if the item was within the state's possession, custody, or control, and the item is material to preparing the defense. The government intends to use the item in its case in chief at trial, or the item was obtained from or belongs to the defendant. He goes on to provide a lot of different information about sanctions that can be imposed by the court for failure to comply with a request, and that's under subsection D2. Which if a party fails to comply with this rule, the court may order that the party to permit the discovery or inspection, specify the time, manner, and prescribe other terms and conditions, grant a continuance, prohibit the party from introducing undisclosed evidence, or enter such other order as it deems just under the circumstances. So one option I have is to simply exclude this evidence. Problem is in defining whether or not the state was really under a duty and obligation to produce these checks. There is some case law that indicates that that is not necessarily the case, and I'm looking for the case that I found here, in which the State versus Parton, which is a 2019 Tennessee criminal appeals case, basically held that the state was subject to a trial court's order to produce documents that were not within their control because they didn't object to it and they conceded to it. And essentially what that opinion by the Court of Appeals says was that payroll documents were not under the state's possession and control, and therefore there was no duty or obligation under Rule 16 to supply them. But that in that particular case, the court ordered that those things be supplied, and unless the state objected to it, that would be a continuing duty and obligation on the state's part. In this case, I've reviewed the document, the transcript of the November hearing that we have regarding the defendant's motions. And I do not find a specific order that these bank statements be produced. There's no order in the file. And as a result of that, I don't find where the state was ever ordered to specifically produce those bank statements. Am I missing something, Mr. Scruggs?
Judge, I understand there was no order, but these are items that they're now going to produce, supply, and try to admit in their case in chief. So with that said, that should have been supplied to me years ago.
Why?
Pardon?
Why? If it's not in their possession and control under Rule 16, does the state have a duty and obligation?
If they're going to introduce it in their case in chief, absolutely.
Where does it say that in Rule 16? I just read you the rule.
Well, I think what you just read said that.
What it says is within the state's possession and control, and that's what I'm telling you is that this case that I've cited to you seems to say that the state does not have in its possession and control documents such as payroll records that are not within the states. If they don't have them in their possession, they can't produce them. That's a difficult scenario from a defendant's standpoint, and I certainly have argued the same thing you're arguing, but the rule is clear that the only obligation the state has is to produce documents within their possession or control. In this case, they were bank statements that were not within their possession and control, and therefore I don't find that they were under a duty and obligation to produce them under Rule 16. However, because of the fact that they have now identified them as being evidence that they intend to introduce, the defense would be prejudiced by going to trial today without an opportunity to review them. And I'm going to give you that opportunity to review them. And then if you have an objection to some portion of them beyond the fact that they would fail to be produced, I'll certainly allow it. But under Rule 16, and that case that I've cited to you, it does not provide that the state has a duty and obligation. If they're going to, if the defense, if the state's witness has some document that's not within their possession, that the state doesn't have any control over, but it comes available to them for trial, then they have a duty, in my opinion, if they're gonna use it, to produce it for you to look at, but it's not under Rule 16. So the best I can do is give you some time to look at these documents and then allow us to reschedule. I can give you a fairly rapid trial date to continue this matter so that you have an opportunity, but in my opinion, it does not meet the criteria for us to exclude those documents. So,
Judge, I think I'm forced to ask for a continuance then.
and I understand that, and I don't want to do it, but I am going to do it because of the fact that it is, what about November the 1st?
Your Honor, November 1st, I will be in a first-degree murder trial.
We're gonna set this at a date. We're gonna have to move some things.
Okay.
Everybody's schedule is gonna have.
November 1st is perfect for me.
Where is your murder trial?
It's here in Dixon County, State v. Welch. Starts the 31st.
How long do you need to review? Realistically,
Oh, I could do this next week if you wanted to do it next week.
unfortunately, I start my term in Humphreys County next week.
I mean, I need a couple days is all. All right. So
What do you have on the 20th of October?
I'm free that day, Your Honor.
Judge, I have an event in my house where we host disabled adults for a
I
picnic.
don't want to interfere with that. How long is your murder trial supposed to take?
I would say, Your Honor, at least 3 to 4 days.
What do you have on the 24th of October?
I've got Houston County Grand Jury, but I'm sure I can find another prosecutor to handle that for me if needed.
My only problem, if we could do this in one day, I could say, let's do it. I have another trial that's set for sure on October the 25th.
Well, I start the judicial conference on the 25th, so the 24th is just a day I have available.
Well, let me ask you this then. Let's just say we did not get it finished in one day. Could we then just select another day to finish it then?
It would be unusual in a criminal case, but not impossible. I've tried criminal cases where because of weather, we had to suspend them and come back on another day. But since it's a non-jury matter, that won't particularly, I assume as long as there's no opposition, if we didn't finish it on the 24th, we could find another day to come back to it.
The 24th would be good for me.
That works for the state, Your Honor.
All right, we will set this case for trial November the 20th or October the 24th. You've given a copy of what you intend to use to Mr.
Yes, Your Honor.
Is there anything else, documentary wise, evidentiary wise, or anything else that needs to be disclosed?
I was gonna go through some photos of all the exhibits I plan on presenting with Mr. Scruggs while we're here. So anything.
Good. Since we are here, we could go ahead and submit what we've stipulated to, if the court would like to hear some of this now.
That's fine. We have our court reporter here, so you can go ahead and make the stipulation.
This is what we got.
See, that's contract.
Contract,
This is a change order.
first change order.
Yep. There it is.
Second change order. I'm marking 3. That was
Yeah.
what I said.
This one, there might be, we can enter this, it's coming in as an exhibit. But she's saying she never did approve it.
Well, I mean, that's because she paid for it. Okay, she paid for it, so.
That'll just have to be litigated.
Well, hold on a second.
If you want to submit like a written stipulation, would that be better? I'm not suggesting you have to do that if you can announce it on the record.
Yeah, we'll go with that.
No, I think we're good on all these. If I could just go ahead and submit to the file. We have our. It's like 6 stipulations. First off is the contract between the parties. We stipulated that that's authentic and admissible, relevant.
Then let's just mark these as exhibits. What I'm
Exhibit
saying.
one,
Oh,
I've already marked them with my exhibit. Change order number one.
Will be marked as exhibit two,
Change order number two.
exhibit three,
Change order number three, along with an email to Miss Bear Monk, confirming the same. And a breakdown of the invoices and payments that were submitted and paid by Miss Bear in accordance with the draw schedule, the payment schedule in the contract.
will be exhibit five.
Those are our exhibit. And we may be able to come up with some more later.
That's fine. You can, we can do that when we come back. Right, then, under those circumstances, this case will be continued until the 24th day of October. I expect that we will start it at 9 o'clock and make sure that there's not any other issues that would delay anything.
Yes, Your Honor.
All right. We'll stand in recess. I have something at 1:30 this afternoon, if I understand correctly, with the Tennessee Department of Corrections in there. So we'll recess court until 1:30.
There's one other issue, since you're here.
Okay.
If we wait till the general gets back.
We may need to run out there and get him to make sure he has some fun off.
No, he said he was coming back.
I think it was went and witnessed.
Yes, Your Honor. One other issue I wanted to raise, and I was going to ask this when we started the trial, and that is I would like to exclude my experts from the rule. In other words, I'll ask that they be allowed to sit in and listen to the testimony of,
Expert witnesses under the rule are allowed to sit in the courtroom and to listen to the testimony of other experts.
I would ask for
So
that.
they'll be exempt from the rule. When an expert witness is testifying, you can bring your witness in for that testimony. I don't know that they're completely excluded from the rule, but I know they can be present and listen to the testimony of others. Let me double check on that, make sure it may be that they're completely exempt from the rule. Regarding, you have any objection, Letty?
No objection, Your Honor.
We'll just let them-
And the same goes for his experts as well.
All the experts will be exempt from the rule. Anything else?
Anything else?
No, Your Honor.
Then we will stand in recess until 1:30 this afternoon. Thank you.
What is now in recess? Yeah, absolutely.
So I was just gonna go through some of these.
All rise. This circuit court Dixon County is now in session. The Honorable Judge David Wolfe presiding. All you have business for this court, draw nine, you shall be heard. God bless the United States, this state, and this court. You may be seated.
Good morning. We have one case on our docket for today, the state of Tennessee versus Christopher C. White. And the defendant has waived, both sides have waived the jury and agreed that this will be conducted as a bench trial. If I understand correctly, is there any change in that today?
So we are ready to proceed.
Stay ready?
Yes, Your Honor.
All right. Wish to make an opening statement? Either side.
No, Your Honor.
You wish to make an opening statement?
Yes, sir. Judge, may we use the PowerPoint to
You should do whatever you like.
Thank you. Please, the court, I'm Mark Scruggs of the National Bar. I'm here representing the defendant hearing, Christopher C. White. And I would like to take the court through what I think the proof is going to show here today. First off, I think that with any type of case, whether it be criminal or civil, that it is critical to identify the law and the issues that are applicable to the particular case. So with that said, I would simply like to start off with a presentation directing the court's attention first to the indictment in this case. If we could go ahead and put that up, please. As the court, I'm sure is familiar with already, the indictment charges Mr. White with a violation of a particular provision of TCA section 39-14-154C1 for activity that occurred between the dates of November 1st, 2014 and October 31st, 2015. It is critical for the court to recognize what the law was that was in effect at that time. This particular indictment claims that Mr. White deviated from or disregarded plans or specifications in a material respect from those contained in a contract for home improvement services, including the amount billed for the home improvement services was substantially greater than the amount quoted in the contract. The materials used in the project were of a substandard quality, but the residential owner was charged for higher quality materials, and the residential owner did not provide written consent for the home improvement services provider to deviate from or disregard plans or specifications in the contract, and such deviations cause substantial damage to the residential owner's property. Under this particular statute, Judge, this type of offense is punishable as theft within the statute. Count 2 of the statute is a indictment generally for theft, but it would be our position that theft is derived, the concept of theft and the offense of theft is derived through this particular statute. Move to the next. As a defense to this particular statute, Judge, which we would be asserting today is 39-14-107, which states that it is an affirmative defense to prosecution under the theft statutes, that the person acted under an honest claim of right to the property or services involved. Here, Judge, we're going to go through a contract. There was, in fact, a very meticulous contract that was entered into between the parties, and the contract should control in terms of determining whether or not Mr. White in any way violated the statute that he's been indicted for violating. Next slide, please. Judge, I would like to bring the court's attention. I've done this previously, and that is that this issue has previously been determined by other courts. For whatever worth the court may choose to use this, these are public records, and the court can use this as persuasive authority. First, we've had a similar case that was dismissed in Robertson County, Springfield, Tennessee, involving another situation involving Mr. White. Next. And likewise, you're going to hear from the facts of the case in just a minute that Mr. White eventually had to file bankruptcy for his company. For various reasons, his company was not able to meet the requirements of some of the contracts he had in effect. In the winter of 2016, He filed a bankruptcy. And one of the issues that was raised by the trustee in that particular case was whether fraud was involved. And in that particular case, the United States bankruptcy trustee, determined that after extensive discovery that there was no fraud involved, and therefore dismissed their challenge to his discharge. Again, we submit these simply as persuasive authority for our position. So what I'd like to do is to focus, at least in terms of my opening statement here, regarding the important provisions of the contract between the parties. Now, first off, you'll see that this is a contract between Miss Rebecca Bear, also known now as Rebecca Monk, and I'll refer to her as Miss Monk, even though it says Miss Bear in here, between Countrywide Barns and Buildings, Inc. And Miss Bear, Miss Monk, that is. If you'll go through the contract, you'll see that this contract is very, very comprehensive and addresses the construction of a new residence, not an existing residence. There was nothing on this property when this construction project started. And as a result of that, this project began with the excavation of property in accordance with the specifications that are set out herein. You'll see attached here too are some plans, architectural plans that were purchased. Actually, I think the architect was recommended to Miss Bear, and she contacted that person, and these plans were agreed upon and attached to the contract. Likewise, you'll see here, it was not just a residential home that was to be built. There was also a garage that was to be built. So if you'll see on the first page of the contract, and by the way, we have stipulated, the court should have in front of it, I hope, if it doesn't already, there should be 6 stipulated exhibits that have already been introduced into evidence herein. This would be exhibit number 1, the contract. And in that particular contract, Judge, you'll see on page 1, number 3, it mentions the specifications for the garage, okay? And the garage is also, the plans and specifications for that are the last 3 pages of this particular contract as well. So we have a residence as well as a garage that was to be built. Now, there are some important items, provisions of this contract that I would like to bring to the court's attention. First, if you would turn to page 3 of the contract, you'll see what is what's called a payment schedule or a draw schedule. But before you see that, you'll see that pursuant to the agreement between the parties, all change orders should be paid at the time of the execution of the change order shortly thereafter. It's important to understand that in this particular contract, Countrywide was not going to finance this lady's house, this job. All right. What you have here is that the customer, Ms. Bear, would pay a specific amount to cover a specific amount of work. And then once that work was completed, they would then bill her for the next portion of the project. That's very important to keep that in mind. And what you're going to see here at the bottom of page 3 is the work/draw schedule. So for example, this particular contract was signed, I believe it was in December 16th, 15th of 2014. We have to assume that Ms. Bear read this contract, understood this contract, and was in agreement with this contract. So the way this works is that at the signing of the contract, in order to get the project started, she is to pay $57,837.81. Now, what you're going to see on, I believe it is Exhibit 6. Okay, let's go ahead and move to Exhibit 6 if we could. Stipulated Exhibit 6. Oh, keep going. All right, 6 is down at the bottom. Okay, and in that particular exhibit, Judge, what you're going to see is the actual payment schedule itself. So it's important to compare those payments that Ms. Bear made with the work that was done. For example, the first draw of $57,000 dealt with the excavation and preparation of the foundation and so forth. The footings, the foundation and all that. All right. So what's important to note about this is that you'll see that the payment was made for that first draw on December 15, 2014. And over the course of the next few weeks, excavation took place, and we'll provide pictures and so forth to show that that's what happened. But it's important to note, Judge, that during this time period, Ms. Baird decided that she did not want a garage. She would rather have a basement. So what she did was she contacted the excavator personally, told him of that, and the excavator, instead of preparing the site for a garage, went ahead unilaterally and began work on a basement. Now, this was in violation of the contract, which is set out on page 6. Page 6 of the contract says, customer acknowledges and agrees that Countrywide Barns and Buildings Inc.'s worksite personnel do not have the authority to bind Countrywide Barns and Buildings Inc. to any agreement, oral or written. Now, this caused some problems, but Countrywide did everything they could to accommodate her and to fix that issue. So you'll note that in the payment schedule that we've just submitted, which is exhibit number 6, you'll see that the first payment and invoice has to do with the architectural plans. Countrywide paid the architect, and then Miss Bear paid them back. You've got $3,872. But after the first draw, you have $57,837, and she paid that. You'll see that. Okay. But then if you'll go down further, you're then going to see some notations here where you're going to see a credit for what the garage was going to cost versus what the basement was going to cost. So that leads us to change order number 1. So let's go on through that if we could. This is
I'm allowing you to make your opening statement, but the state has the burden of proof. And I am not considering any of this evidence because it may have been marked as an exhibit, but you have not begun to put on your proof. State goes first in any criminal case. So I'm allowing you to make an opening statement, but I'm not going through these documents as you wish, because in a criminal case, the state has the burden of proof and they have the right to put on their proof first. So even though these have been marked as exhibits, I'm not considering them until the state begins putting on its proof, and then I will consider those exhibits. But I'm listening to you. I'm just not going through each document that you're putting up on your screen, simply because proof has not yet begun to be offered.
I understand.
This is not evidence, this is argument.
I understand. Well, Judge, this has been stipulated as admissible and relevant and so forth. So
The state, by stipulating that, the state is agreeing that those things can come in whenever the state starts putting on its proof, but proof has not yet begun in this case. So
I understand.
All right.
The point I'm simply trying to make, Judge, is that the statute that he has been indicted on is dependent upon the written contract and the transactions that occurred pursuant to that written contract during the course of the construction. That's simply what I'm trying to do, Judge. So the court is aware that during the course of the construction, there were draws that were made, okay? But the request for payments came after work was done. In other words, she paid as she went. And I guess the disputes didn't really occur, and the construction period really and truly is during 2015. It's almost entirely in 2015 here. The disputes did not occur until probably August or September of 2015, but change orders were placed and payments were made such that everything that Mr. White did was in pursuant to a written contract or a written change order that was agreed on by the parties. So, I mean, I can sit here probably for a couple hours, I guess, and go through this, but nevertheless, I'll let the state go ahead and make their case, but
That is the way the criminal process works.
I understand, but I think it's real important here for the court to understand the sequence of events and the payment schedule, because the statute itself depends upon the written contract and the amount that was quoted in the contract that was agreed upon by Ms. Bear. And the fact of the matter is that the court's going to see that there is no proof whatsoever that Mr. White ever used substandard material or varied from the contract without her consent and approval. And when it all comes down to it, Judge, what you're going to find is that when Mr. White finally left that job, she actually owed him money on the contract. He had performed work on that house above and beyond what he was being paid through the draws. This is a vindictive prosecution, and we will show that it is without any legal support.
Well, I know you waived opening statement at the beginning, but you have the right as a state to make a rebuttal if you choose.
I don't know, Your Honor.
And the lights on, the story first witness.
They will call, Michael Monk. Good morning. Can
Good morning.
you please state your name for the record?
Rebecca Colleen Monk.
And did you used to go by Rebecca Bear?
Yes, sir, I did.
And there'll be some documents in this case. And what would your name be in these documents?
Rebecca Bear,
Where do you currently reside, Ms. Monk?
3074 Sylvia Road, Dixon, Tennessee, 37055.
Now, is that the house you're currently living in? Is that the house that's, while we are here today?
Yes, sir, it is.
Do you know the defendant, Christopher White?
Yes, sir, I do.
How do you know Mr. White?
I hired his company to build the house that I reside in.
And what was the name of his company?
Countrywide Barns and Buildings or Homes.
And when did you hire them to build this house?
I originally reached out to them November of 2014. I spoke with his salesman, Chris Morris. Thereafter, I met with them, and it was December of 2015. Or sorry, 2014.
You eventually enter into a contract for Countrywide to construct a house for you.
Yes, sir.
Identify this document.
This is the contract that I signed. Stating what we were to build.
I believe this, Your Honor, this contract has already been entered in as an exhibit.
This is exhibit 1.
Okay.
And when was it marked as an exhibit?
Last time we were in court, yes.
Last time we were here in court,
Yes, Your Honor. We got it.
even though it's been marked as an exhibit by agreement, it will be marked as exhibit 1 to this trial. Keep in mind that we're trying this case as if this was a jury trial, but the only difference is I will be the one to make the verdict. And so it's the same procedure will follow, even though you may have agreed to do that, you still need to make them the record today so that whatever happens, if there is an appeal resulting from it, it's clear on the record what has taken place at this trial. What took place prior to the trial or pretrial proceeding Today is a trial that starts, and that's what I was explaining to Mr. Scruggs. This is a criminal trial. It's not a civil trial. It will be conducted the same as a criminal trial.
Yes, Your Honor.
So this is, the contract will be marked as Exhibit 1.
How are you supposed to pay Mr. White as far as constructing your house?
Based on draws. I would write them a check at each interval when they reached a certain point of the draw.
Based on this contract, when was your house supposed to be? What was the completion date supposed to be?
Originally, I believe I was told Easter of 2015.
So about April of 2015.
Yes, sir.
It's about 4 months.
Yes, sir.
Did you have any concerns about this contract prior to signing it?
No, sir, not to my knowledge. I read it as best I could. It's pretty heavy reading.
Okay.
But upon signing it, no, everybody, it was a happy moment.
After signing it, did you have any concerns with the contract?
I did. After things started to kind of go amiss, and my efforts to reach out to Countrywide to get them to come out to the property, specifically about the grading. They wouldn't show up, or nobody would come out. There's emails.
Says I'm going to object to the relevance of this in relation to what the indictment states here. In terms of whether or not there was some issue she had with the timeliness of the construction or anything like that. I'm just not sure. I would submit that that's not relevant in this particular case. To this indictment.
Your Honor, the indictment says intent to defraud. That is a key point that Mr. Scruggs keeps forgetting about, I believe.
So ruled I'm going to allow the evidence in because I think it apparently goes to the state's effort to try to set the overall background of the situation.
Thank you, Your Honor. Did the original contract include a basement?
No, sir, it did not.
Can you explain to the court how this basement come up in this construction?
There were several emails back and forth between myself and Countrywide regarding the grade. The contract states that we were responsible for providing a level building site. I am not a builder, so what looked level to me was in fact not level. It had more than a 6-inch grade to it, which is what I was.
Judge, I'm going to object to her giving an opinion as to what the grade is. She's already said she's not a builder, giving an opinion on specific grades. I would submit it as a matter for expert testimony.
The objection is as to this outside the scope of her testimony and rendering an opinion. Because she's not an expert.
Yeah, but she was talking about what the grade was in terms of what she believed the grade to be. And I would submit, Judge, that you would have to have expert testimony for that. She's already said she's not a builder. This is not her area of expertise.
The purpose of showing and introducing is
We'll move on, Your Honor. I just wanted, was,
objection.
how did the basement come up? Did you want the basement? Well,
Originally, I did not want a basement. I wanted a concrete slab. It was determined that there'd be too much gravel to be hauled in. So Countrywide we talked back and forth, and they told me that I would be better off doing a basement based on the amount of gravel to bring in to level up the site. That was based off of emails that were back and forth to where I was asking them to come to the house and look at the site. And specifically, I believe the email stated, when is somebody going to come out and look at this to make sure it's at grade? So after they told me the pros and the cons about either bringing a whole bunch of gravel in or doing a basement, I decided, okay, we'll do a basement.
Was there a change order to that?
Yes, sir. There was a change order to that prior to anything being dug.
I'll pass up a document to you. Can you identify this document? Is this the same document on the screen right here?
Yes, sir. This is, I had requested a balance or a account of all payments from Countrywide, and Sasha Johnson provided me this.
So these are all the payments that you paid Countrywide.
Yes, sir, except for I did mess up. And on the one that says 20,339.28, that was actually the credit for, because we had to do the basement, I no longer had the funds to do the garage. And I was concerned about it based on, I couldn't even get them out to the site. So we nixed the garage. But everything else is payments.
So the highlighted on 1/14/2015, the $31,000, what is that significant? Is that the,
That's the basement.
that's the basement, okay. And what about on 7/13/2015? The 13,000? Is that where you explaining?
That's another change order. I believe it's because the way that the basement was dug, the dirt mover came out and moved too much dirt. I contacted Countrywide that day stating, I don't know what to do. He's asking this, that, and the other. Their dirt mover.
And at the end, it says total $47,069.49.
Yes, sir.
Is that what
That's what they say that I owe them.
that you owe them? Okay. You dispute that?
Yes, sir.
How much did you pay Countrywide for this house?
209. I can't remember. Originally I thought it was 316,000, but it's 316,000 minus that 20,000. So 291, I think.
So $291,000.
Roughly, yes, sir.
That's what you paid.
Yes, sir.
I'm gonna give you, Scott, I'd like to enter that. The sheet she has as the next exhibit.
Like exhibit 2, that's the document that's on the screen, is that what you're?
That's correct, Your Honor.
Two.
So the next will be a collective exhibit. People that don't file the documents, I'll just show you.
These are the invoices.
What are the
The
dates on those invoices?
dates.
Yeah.
I have 4/9/2015, 8/13/2015, 10/1/2015, and 10/1/2015.
Gave me them.
Yeah, you gave me the
What are the amount of these invoices?
57,837.80. The doors and trim, 1,873, and 57,837.80.
Now, when you would pay an installment, around $57,000. Did Countrywide subcontract out to other subcontractors?
Yes, sir.
Is that a part, is that in the contract?
Yes, sir, I believe.
So when you would give a lump sum amount of $57,000, would it be Countrywide's responsibility to use that money to pay the subcontract?
Yes, sir.
That didn't come out of your pocket?
No, sir. Well, sometimes when I would go to the job sites, the contractors were telling me,
Judge, I'm gonna object.
They
to the
weren't getting
hearsay
paid.
At this point.
You're gonna object?
That's your say. I just want, that's okay.
Object to the hearsay, yes, sir.
I'll move on now.
Abstain?
But the agreement was you were to pay the lump sum. It was Countrywide's responsibility to pay the subcontract.
yes, sir.
That was not your responsibility.
No, sir.
Your Honor, I'd like to enter these invoices as the next collective exhibit.
These are, how many on invoices?
There's 3 of them, Your Honor.
Mark them collective exhibit 3, A, B, and C.
There were a couple change orders, is that correct?
Yes, sir.
What were these change orders for? Off the top of your head, you recall what they were for?
The first one was for the basement. That's
Okay.
change order number 1. Change order number 2, I believe was for a retaining wall. Change order number 3, I did not pay because I did not agree to the work.
And we'll get to that.
I'm sorry.
I just want to give you a copy of all these change orders.
This is my copy. Do you want this back?
I need it back. That's what I'm gonna have here. So these are a copy of change orders in this case. What I handed you.
Yes, sir.
What was the first one dated?
December 15th, 2014.
What was that one for?
That was for the basement.
Now, there's 2 dates on here. There's one January 12th, 2015, and one
Oh,
December.
sorry. Yeah, date January 12th. I don't. It's 2.
Is that the date that it was agreed upon?
Yes, sir. I signed
Change.
it January 13th.
The next one, what date is that for?
January 13th.
What was that for?
That is for the deductive sum of 20,339 for the removal of building.
Of the garage that was supposed to be,
Yes,
is that
sir.
correct? And so that changed the total amount of the value of what the house is gonna cost you, about $300,000.
Yes, sir, because it takes into account 31,000 already.
The next change order, what is that?
Change first floors from 8 foot at a cost difference from 7 foot,
What date is that for?
January 22nd.
Was that agreed upon?
I don't have a signed copy of that one. Original.
You recall agreeing to the change of the doors?
It was part of the original contract. When the initial process with Countrywide is they send you this form and you circle the things that you want.
Yeah.
I wanted 8 foot doors and it stated that on that original thing. But I mean, that is
Regardless.
accurate. We have 8 foot doors.
Yes. Okay. The next change order, what's that for?
That is for the retaining walls.
Is that on July 2nd, 2015?
Yes, sir.
And which, is that, did you agree to this?
Yes, sir.
That increased the amount to 314. A little over 314.
Yes, sir.
Now, wouldn't, because of having a basement, wouldn't you have to have retaining walls anyways?
Yes, sir.
And the last one, what's the date on that one?
10/9/2015.
What was this change order for?
This was for basement bathroom, porch, concrete pad under porch, metal to cover block, interior door, additional side door, floor filling, wall, and remaining current on draw. At this point, there were points that they had not finished with the framing, and they still wanted me to pay a full installment to go to the next, and I refused to do that because what I'd already paid for still was not done.
And you didn't agree to this change order?
No, sir, I did not.
And that's because they hadn't finished the installment.
They didn't finish the other installment. I never asked for a basement bathroom. The side porch, it was already supposed to be there because I wanted a full wraparound porch.
Did you get a full wraparound one?
Yes, sir, I did.
Was it concrete or was it wood?
Wood,
What did you
concrete,
contract for? Was that the original contract?
concrete, yes, sir, an original contract.
I'd like to enter those change orders as the next collective exhibit.
This next collective exhibit, we'll hand those to the clerk.
Now, I'd like to go through some photos of the house. When did Countrywide break ground on your house?
I believe it was in January or February.
January
2015.
2015?
Yes, sir.
Notice any issues when they first started breaking ground?
Yes, sir.
What were those issues? Can you please tell me?
Their subcontractor who was excavating didn't know what to do.
How can you tell that?
He told me, and
Judge,
He
I'm
was-
gonna object to your
You
saying.
can't say what he told you.
okay, he was asking. There were
Okay.
questions brought up as to how they were supposed to dig out the entry to the basement.
So there was issues with the basement
Yes,
from the very beginning. Is that
yes,
correct?
yes.
When did, Countrywide stop working on her house?
It was October or November of 2015.
No. They don't have pictures. Did you take some pictures of your home
Yes, sir.
in that time frame?
Yes, sir.